Thank you so much, Justin, for this and everything you did for this program, and welcome all. Those who've attended Berkeley Judicial Institute programs before, and I'm grateful for those who have, know what comes next. A brief and painless advertisement for Berkeley Judicial Institute. Now that we have you here, we'd love to see you back. Check out our webpage where you'll find registration links for future programs, recordings of past programs, interesting things to read and to watch. Consider joining our mailing list so you can keep up to date with what we're doing, or follow us on social media. Wasn't that painless? And now, the reason you're really here. We have, thanks to Judge Marcia Krieger, our fearless leader, assembled a spectacular faculty for today's program. I'm going to give the quickest of introductions to the extraordinary Judge Krieger, and she'll introduce the rest of the faculty. Judge Krieger is a federal district court judge in the District of Colorado. Her judicial service includes time as a bankruptcy judge. Throughout her career, she's been strongly involved in civics education and civics engagement. And she can correct me, but I believe that it's that work in civics education, that gave her a better understanding that citizens get their information, their good information, and sometimes their slightly off information largely based on press coverage of big crimes, big criminal trials, big issues. And that might encourage someone to wring their hands and say, what shall we do? It encouraged her to say, let's make things better. Let's help judges and the press connect so that the press better understands what we do and why we do it, and then citizens better understand what we do and why we do it. So that's the world's shortest introduction to an extraordinary person. Her biographical link and the biographical links for all the faculty will be in the chat. But with that, let's turn things over to Judge Krieger. Judge Krieger, where will we start today?
Thank you, Denise. That's a very kind introduction. And actually, I want to return the favor by saying thank you to you and to BJI for hosting not only this program, but a number of other programs that concern the relationship between judges and courts and the press. I'm convinced that it is the journalists who help educate the public and, to a greater or lesser degree, inspire confidence in the judicial process. And therefore, it's incumbent upon us as judges and as lawyers to explain to journalists as well as the public how we work, what we do, and why we do it. Today, we're focusing on jury trials, and jury trials, especially in criminal cases, are often the subject of news reports. In fact, news reports are the primary source of information, along with entertainment sources like movies and TV shows, etc., for the public's knowledge about the legal system. Truly, the public wants to believe that the judicial process is fair, but they often don't understand how it works. More than any other source, the press affects public views as to whether trials are fair and trustworthy. So let me say thank you to all of you for joining us today, and particularly for those of you who are involved as journalists or have an interest in that area. One of the most mysterious aspects that we have with regard to a jury trial is the role of the jury. That is what we want to discuss today. And with me is a most illustrious panel. We have two academics, Professors Valerie Hans and Nancy Marder, who have extensively studied and written about juries, why we have them, how they work, how they differ from juries in other countries, and how we can best assist them in their tasks. I'm not going to recite their extensive and impressive credentials because they're posted for you to review, but I commend to your reading two of their recent books, The Power of the Jury by Professor Marder and American Juries, the Verdict by Professor Hans and Neil Vidmar. Those are books that really get to the heart of what we're talking about today, and I'm so grateful to our professors for joining us on this panel. We have two other experts as well, and they are judges who preside over jury trials, both in the state court system and in the federal system. From the state court system, we have Judge Pamela Gates, who sits in the Superior Court of Maricopa County in Arizona. She recently was awarded the Thomas Munsterman Award for Jury Innovation from the National Center for State Courts. And we also have Judge Robert Lasnik, former Chief Judge of the United States District Court for the District of Washington. And he has a number of different interests in his background. At one time, he studied journalism. So with that, I'm going to ask him to tell just a little bit about that aspect of his career.
Thank you very much. I attended journalism school at Northwestern right after I graduated from Brandeis with a degree in psychology and sociology. I then got a master's in counseling. And I come from one of those Jewish families where my mother said, Bobby, there's no such thing as too much education. And then after I went to law school, she said, you know, Bobby, there is such a thing as too much education. And I stopped there. But I was always interested in communication, one-on-one counseling, one on small groups, jury trials, one on large groups, journalism, and writing opinions that you know are going to be read by either the entire bar in your community or by the entire country. And so I think they're all related in the sense of how you communicate. And, you know, when I first started out as a prosecutor in Seattle, doing, you know, really high profile criminal cases, we had at all the major newspapers, people who were dedicated to covering the courts. And they had a great deal of experience and sophistication about jury trials. Nowadays, you may never see the same person twice in a row from different media outlets. And there's a need to educate at the same time that I'm happy to do. And especially if people have questions that don't go to my case, but they're like, what is this Iqbal Twombly thing that I keep hearing about? That's a hard concept to get your arms around. Or why was that case removed to federal court, but then sent back to state court? There's a lot of very tricky legal concepts that I think judges have a responsibility to try to help educate journalists about. And in terms of the jury trial, you know, we don't in federal court allow reporters to talk to jurors. And I think that's actually a good thing. I like to keep the jury isolated from the media while they're doing their job, at least until they're excused at the end of the case. But answering questions about why we do this way or why we do it that way, I think that's part of our responsibility as judges.
Thank you, Judge Lasnik. Let me open the discussion here with a question for our professors. Why do you think we use juries in the criminal and civil trial contexts?
Well, juries are a key part of both the criminal and civil legal systems, and I think they are justifiable for a number of reasons. First of all, it's democracy in action, and a representative jury, one that reflects the broad range of opinions, knowledge, experience in the community, all of those perspectives and experiences can be brought to bear on the interpretation of evidence in the case. So it's really makes the case for juries being fairly strong fact finders who can bring that experience and knowledge to bear. But that is not all. And maybe some people might even say that's not the most significant thing, because juries are also political institutions. They can be a counterweight to maybe prosecutors who don't really have what it takes in terms of the evidence to bring a strong case against a criminal defendant, for example, or with all due respect to the judges on this panel, maybe a jaded judge. And so it's part of our founding documents, the way that juries really provide this counterweight and balance in the kind of checks and balances of our system. The other thing is that it has an effect, serving as juror has an effect on the jurors themselves. They come away typically with greater support and belief in our jury system and in our courts, and are more active in their communities than they were in advance. So they get educated, they get more engaged. And I wanna just add a quote from the wonderful judges Patrick Higginbotham and Lee Rosenthal and their collaborator Stephen Gensler. They said, "Every empty jury chair is a missed opportunity to strengthen the bonds between the people and the courts." So those are some of the reasons why juries are such a central part of our system. Nancy?
Yeah, I guess I would add, acknowledging that jury trials are time-consuming and expensive. So not every case goes to a jury trial, but certainly the hard cases should. The civil cases that can settle, and many do, or be decided on a motion by a judge, or the criminal cases that reach agreement, plea agreement. But there are cases that are really hard cases, and we need a mechanism, and the jury trial is that mechanism. And it's a way of reassuring people, our society, the community, that it's going to be a fair trial, that these are ordinary citizens. They have no stake in the outcome of the case. They're not connected to the parties. They're coming from their private life, and they're being put in this sort of public position, this civic position, and they're performing it usually well. And then they're returning to their private life. So there's a sense of that they have no connection, they can be fair, and that there's a legitimacy that goes with that, and a sense in the community they might or might not agree with the verdict, but they agree with that mechanism of resolving this hard case. And of course, we have it embedded in the Constitution that you have this right to a jury trial, in the Sixth Amendment for criminal cases, and the Seventh Amendment for certain kinds of civil cases. So as Professor Hans said, it's part of our roots, of our founding, and I think we take it quite seriously as a society.
I would agree with that, and I'd go on to say that it's interesting that you both talk about something that goes to American identity, and that is our jury system. Now, I know, Professor Marder, you have studied jury systems in other countries, and I'm interested in whether you think that the 12-person jury that we have in popular culture here is also something that is peculiarly American.
Well, it seems to us peculiarly American, but it is rooted in other countries. We got our jury system from England. I've spent time observing jury selection in Canada. They take their jury service very seriously, and it's very formal there. It resembles more closely what goes on in England. So what's so interesting is we who have jury systems take it very seriously, but you can see variations. And so it feels familiar in some ways, and yet there are distinctions that pop up in different countries and in their jury systems.
Well,
I'm sorry to interrupt, but there is something, I'm not going to say magical, but almost magical about the number 12. In our juries, we want to represent the range of people in the community, and juries of size 12 seem to do a pretty decent job of that. Much better than, for example, juries of size 6, which some states have in their civil systems.
I think a lot of people expect a jury of 12, even though there is the opportunity to have a smaller jury, both in state courts and federal courts. Let me turn this over to our judges a little bit and ask if you can give us sort of a thumbnail sketch as to what you see the function of the jury as being during a trial and how it's different from what you do.
Well, I'll start. So I think the point of a jury that is different from the judicial officer is they are bringing their collective wisdom and knowledge. They're collaborating, they're communicating with one another to synthesize all of the testimony and collectively determine what they believe the facts are, and apply those facts to the law. And Professor Hans said something in her initial remark kind of about the fair cross-section of the community and how that's so important. And I'll give an example that I grew up in a small town in rural Iowa. And when I think about out here, I was doing a settlement conference with an individual who was alleged to have started a car with a screwdriver and was facing a charge for theft of means of transportation. And we were discussing the fact during the settlement conference that many of the jurors will have driven to court having started their car with a fob or a key. But having grown up in rural Iowa, starting your car with a screwdriver was nothing foreign to me. So it's that diverse look at the facts and the testimony to be able to say, this is my view of the case. And I think that's incredibly important, magical, to steal the word that was used earlier, that magic that happens within a jury. The judicial officer, many times a case is submitted to the judge rather than a jury, and we are the finders of fact, and we engage in that same process that the jury does. But oftentimes the judge's role is limited to deciding issues of law. And that is something we're incredibly comfortable with, having been law trained. But we do have to recognize that many times, either as the parties are stipulating to us being the finders of fact or based on the applicable law, the case is submitted to the judge. So sometimes we do act as the jury.
I think it's good to go back about a quarter of a century. And, about 25 years ago, there was a lot of talk about doing away with juries, at least in civil cases, and a lot of criticism about we need experts. We can't have ordinary people there. I don't hear that much anymore. And I think that's a tribute to the fact that courts like Judge Gates, Maricopa County, have made changes in the jury system that makes it more vibrant, that makes it more relevant, and makes it more just. And whether we're talking about allowing the jurors to ask questions, whether we're talking about showing a video to them on unconscious bias, or striking or doing away with peremptory challenges, there's a lot going on to try to make the jury system fairer than it was. And, it wasn't all that long ago that women were not likely to be on juries, that African Americans were eliminated time after time on juries. And we have a much better system now, which is, I think, a tribute to both the bench and the bar stepping up and saying, we got to do better here.
Well, if you were to put your finger on something that you wished people knew about the jury system, what would that be? Both from an academic perspective based on your research and also from an experiential perspective for our judges who preside over jury trials. What would you like the public and the press to know?
Well, I wish that in the coverage of the Trump trials, there had been more attention paid to the fact that this was, these ideas that this was some sort of a biased prosecution, or Merrick Garland controlled this or that. A jury heard the evidence, heard the testimony, listened to the arguments, read the instructions, and returned a verdict. And I don't see a lot of reference to that, both in terms of the federal trial in front of Judge Kaplan and the state court trial in front of Judge Marcia. Now, I also think when you read about how they run a criminal trial in New York, you want to scream. What do you mean? The jurors don't get a copy of the instructions? Don't get one each? They don't even get one. That's just nuts. And, why are they reading the instructions after the arguments rather than the other way around? So there's a lot still to be done. But I think the media needs to give more credit to the fact that a jury of the defendant's peers made a decision, in one case beyond a reasonable doubt, in the other case by a preponderance of the evidence, and that's deserving of respect.
So I'd like people to know that they should not throw out their jury summons when it arrives in the mail. I know that the initial reaction is, no, I don't want to do this. I'm too busy for many people. But that's the wrong reaction. They're going to regret it. It's a mistake because the people who respond to their summons and go to the courthouse end up usually having an amazing experience. As reluctant as they might have been to begin with, they are acculturated into the jury process. They learn what they need to do and they become part of the jury. And it's the kind of experience that stays with them for the rest of their lives. So if you meet somebody at a party or if you don't have conversation, ask them whether they ever served on a jury, and they can go back in their memory, 20, 30 years ago and tell you exactly about that experience. So this is something that most people don't know. It's not necessarily treated with great respect in popular culture and newspapers and press reports, but this is something that everybody should take account of.
I have an assignment in a seminar I teach on the jury here at Cornell Law School. I ask the students in the seminar to interview a juror, somebody who has served as a juror. And I think it is probably one of my most popular assignments because people really come away with a sense like Professor Marder was describing, that this is really an extraordinary experience for most people and one that stays with them. We're not always given this opportunity to engage directly in self-governance like this, being given the responsibility to have control over and determine the outcome of a serious case, whether it's a civil or a criminal case, guided by a judge, deliberating with other people who are often quite different from you. And the experiences that our students get by interviewing jurors, I think, really reinforces this idea that it's a truly extraordinary opportunity. And don't throw out the jury summons.
Just to supplement what my colleagues have shared, one point in connection with Judge Lasnik is that different states and different courts have different jury practices. And I think it's important for the press and for the public to understand that. So when they see televised coverage of one trial, but their experience was different, for them to recognize that the procedures may differ from state to state, but the fundamental tenet remains the same. And that is a fair cross-section of the community is sitting in judgment of the individuals in a trial, and they are serving as fair and impartial jurors to determine what the facts are based on the evidence and testimony presented, even though there might be small differences and you don't get jury instructions or you do. The other thing, kind of another supplement to one of the comments of a colleague, is that in addition to don't throw out the summons, is to understand that we as courts work very hard to try and address the obstacles that jurors experience. And not to just immediately think, I can't serve on a jury because I have to work, or I'm not going to get paid, or there are other challenges, they're just going to strike me. To understand that there There may be practices in place that allow you to be a juror. So for example, in Arizona, we made some jury reform to allow jurors to have income replacement up to $300 per day for the totality of their jury service if you are serving on a Superior Court jury. So recognizing that we are putting in place some practices to make sure that you can serve as a juror. And the final thing I would say, and supplement to one other comment from our colleague, is that importance of understanding the fairness of the trial because citizens participate. We have a little slogan here in Arizona that it's fair because I was there. And that is what our jurors are experiencing. And when we as judges ask our veneer members about whether they've had any jury trial experience before to help the parties assess whether they can be fair and impartial, almost without fail, those individuals can recall their prior jury service, even if it was decades ago. If I asked them whether they were, what their work experience was 20 years ago, they probably couldn't tell me with that level of specificity, but they can immediately recall they served on a criminal jury. It involved armed robbery. They were not the foreperson, and they returned a verdict of guilty or not guilty. And it's fascinating to see how vividly they recall that experience.
I want to add to that I think that one of the things that I would like to clarify is that the role of the jury is to find facts. They're not there to determine who's the good guy and who's the bad guy. They're not there to pay attention to what people wear on the witness stand or what people in the gallery are saying or doing, or are there famous people in the gallery or not. They are instructed, both in federal and state court, to pay attention to the evidence. And it is the evidence from which they find the facts. We had a recent press coverage of a judge's determination to set aside a jury verdict. It was in the news, and if you read the articles carefully, you understood that the reason that the judge set aside the verdict is because the determination of the damages did not comport with the evidence. And in fact, it was based upon evidence that had been excluded. So what the judge was saying is not that he or she did not have faith in the jury's determination, but that he didn't follow the instruction to limit themselves to the evidence that was presented. And that's part of the reason why we as judges protect the jury and keep them safe from interference during the trial process. I used to say to jurors when they were selected that immediately when they went home, they would be asked, "Were you selected for a jury trial?" And they could respond, yes. And then they'd be asked, "Well, what's it all about?" That they could not answer. Why? Because immediately when they answered that question, there would be a response, and they would begin to see things from someone else's perspective that was not there in the courtroom, and a perspective that was not reflected in the evidence.
I always agree with that, Judge Krieger, but I give them something they can say to their family, which is, "We have a great judge. He's super smart and very funny."
And I'll tell you all about it once the trial is over. That's for sure. It's interesting that the jury instructions that are given both on the state court level and also in the federal courts are similar. They tell jurors what they can and cannot do. They can't research on the internet. They can't look up witnesses to see what they've said in prior circumstances or what their background is. They have to limit themselves just to what is presented in the courtroom. And that's part of the "it's fair because I was there." It's the magic of what takes place in the courtroom, evidence that can be tested, not stray comments that one might find from other sources.
And the other thing, and the journalists get very mad at me when I say this, is I will say, don't read any newspaper coverage or television coverage. I will say, is there anybody who had something in their work life that got a lot of media attention? And some people raise their hand. And did the media get it right? And they all shake their heads, no. So yeah, you can't trust that. You need to hear the evidence here in the courtroom.
And I
Judge,
used to
what you're
instruct-
saying actually illustrates, I think, one of the ways that we can make these instructions to disregard, to not pay attention, more powerful, which is don't only give an admonition, but explain why it is you're giving that admonition. I mean, here's and you gave a perfect example. Don't pay attention to what the media is saying about this, because in your own experience, there is often a big gap between what is actually happening and what the media reports it.
Sometimes jurors will have questions when the case has been submitted to them for determination, and their questions concern the jury instructions. One of the reasons that we are so careful about telling the jurors not to look for other sources of information is so they can come back and ask questions of the judge as to what a jury instruction means. And that gives the parties an opportunity to weigh in on the explanation that is given so that it is as correct as possible, or if someone doesn't think it's correct, they can make an appropriate objection that they can then raise on appeal. What could we as judges do to demystify the judicial process, do you think? I'll ask our academics to weigh in here because you've done some research with regard to that. I know that Professor Marder has a theory about educating jurors. Would you share that?
Sure. So my theory, which I present in this book, is that when jurors come into the courtroom, they don't need to know anything about the process, because they will learn that throughout every stage of the jury process. So the voir dire, which is the questioning of jurors, through the instructions, ultimately the deliberations, and even in some cases when there's a post-verdict interview at the end with the judge. So every stage of the jury process helps jurors to become jurors. So you don't have to be ready-made as a juror, but rather you are going to go through these stages and learn behaviors that are appropriate to be a juror. And so what that does is that sort of opens up who can be a juror, and it makes it so that it's a much broader swath of the community. And this is good, as we've been talking about it, because you want the jury to be as diverse as possible, with as many different experiences and perspectives with which to test the evidence and to see how credible the group ultimately finds it.
We have a question that builds a little bit on what you just said, and that is how jurors are selected. Is there anyone who'd like to address the question of jury research and mock trials as a way of selecting juries? Professor Hans.
Sure, I can talk a little bit about that. Over the last several decades, it's become increasingly common, especially in big dollar value cases or high profile cases, to use trial consultants. And one of the things trial consultants do is to try to get a sense about the best way to present their side of the evidence of the case. And they use a whole variety of techniques. One of them is focus groups, getting a small number of people together and asking them about key issues in the case, or it might involve community surveys where they ask a larger number of people how they might be leaning. And then look at some of the characteristics of people. Attitudinal characteristics are most significant. Characteristics that would lead them to be close-minded in terms of interpreting evidence. And so what attorneys who employ these trial consultants can do is to use that to identify people who they would like to challenge either for cause and get the judge to exclude them from the particular jury, or in states other than Arizona, peremptorily. That is, to use a small number of challenges that can be given without any reason. So that's the approach that trial consultants take, and they contribute to lawyers' advocacy in the phase of jury selection anyway. There's some debate about how successful it can be and how successful it is in cases. I mean, probably you are able to identify people at, far ends of the spectrum, far ends of the attitudinal spectrum. I think we saw that in the Trump trials that Judge Lasnik talked about. There were some people whose views about former President Trump were so extreme that had they sat in the case as jurors, they probably would not have been able to evaluate the evidence with an open mind.
I think that consultants can help lawyers on their presentation, but I don't know that they can really come up with a profile of these are the jurors you want, because people are very, very different. So I think a lot of it is wasted. But I also think there's a tendency for lawyers to sometimes overthink jury selection and get so strategic that they don't see the forest for the trees. And that's where they can get into big trouble about who that person in seat number 7 is not going to get along with that person in seat 8. So I'm going to leave both of them on. Well, didn't you just hear what that juror number 8 said about this or that? No, because you were just focused on that black man and that white man are not going to get along. So, we talked about how diverse the juries can be. It's an experience. I mean, think about how many times in your life are you with people who are anywhere from 18 years old to 81 years old, people who still remember when I hand out a notebook how to take notes, and kids who are like, what the heck do I do with this? Give me my phone. Most of the time you're with people in your church, your job, your neighborhood, but you're not seeing the other people. But on juries, and it brings long-term friendships to a certain extent too, between people who would never have met each other except for jury service. So I think it's a remarkable process we have, and we should look for ways to make it fairer and weed out, racial prejudice, unconscious bias, things like that. But let's keep it going.
And so
Yeah,
forgive me, I'm going to be the voice of God for a moment. I'm going to say first, I can't believe the faculty is responding to questions in the chat. Yay, all of you. But you have a hot bench here, Judge Krieger. So I'm just going to throw out some questions in not particularly great order so that you can think about them a little bit and comment on them at your will. How does adherence to rule of law affect willingness to serve on a jury? Is it true that the judge's ability, that the jury's ability to do a stellar job relies heavily on how the trial judge rules on admissibility issues? Can jurors see beyond the judge's rulings? And this Professor Hahn popped in on this one. In criminal cases, do juries or bench trials produce more guilty verdicts? How about civil? And we're not done yet. There's more. I'm curious about the press interest in detailing juror members during voir dire, including photos of potential jurors. Would love some comments on that. Some questions hearkening back quickly to what Judge Lasnik just said. If those summoned are excused for things like hardship, do we in fact end up with a diverse and representative juror or a jury, or is that an issue? concern about these are my words, not the questioner's words, the influence of one particularly perhaps extroverted or informed juror trying to dominate? Could court-appointed moderators in the jury process be helpful? And then they'd like to talk about social media. Unfortunately, we only have 75 minutes, but go ahead. And I'll get back to the questions. Great questions. Thank you so much to all of you.
Let me take on one question there, and that is about fair and impartial juries. And I think it harkens back to something that I used to say to lawyers frequently. You, using all of your tools and knowledge, are not really looking for an impartial jury like I am. You're looking for a partial jury, a jury that will rule in favor of your client. And so the process by which we select jurors is critical. And what we're not looking for necessarily is the perfect jury. And we probably, even if we had 12 members of a jury, couldn't get everything as diverse as we would like. But we can select people who appear to be able to base their decision just on the evidence that is presented in the courtroom and follow the rules that the judge gives as to the law. And that is the definition of an impartial jury.
And I'll take a couple of the questions. I'll talk about the question regarding the judge's ruling on the admissibility of evidence, and does that impact a juror's perception of the trial? I think it's important for us to explain to jurors and to the public why we as judges follow the rules of evidence that we do. And I think if you generally understand that the rules of evidence, the rules of court procedure, are in place to ensure reliability of evidence, that it helps the jurors understand why they are receiving the evidence that they are. And I'll give you an example. So I usually teach trial advocacy at different levels. And I try and always explain that the rules of evidence make sense, and they should be that use of critical thinking that we use in everyday life. What's reliable? You think about something like character evidence. So going back to that small town I grew up in, my dad got his car stolen. The law enforcement officer came to my house. Growing up, we always left the keys in the ignition. Nobody locked the doors. And my dad got his car stolen. And the police came out and said, it's either Chad or Eric. And the police believed it was either Chad or Eric because Chad or Eric did bad stuff. And so they already believed that the perpetrator of this crime was going to be Chad or Eric. We don't allow that type of bad acts, those prior acts, to relieve the person, the entity, the party with the burden of proof. They have to prove that this individual committed this crime on this day based on reliable evidence. Not the fact that Chad and Eric got in trouble a lot in the past. So why don't we just lock them up now? And it's that type of understanding when I try and go back and speak to the jurors, not about the case, but giving them that legal information, helping them understand what hearsay is, helping them understand why certain evidence can't be considered by the jury. The jurors seem overwhelmingly in agreement with understanding, oh, I get it, because the rules of evidence make sense. Briefly, the other point I wanted to just reference was the comment regarding hardship. If we are removing individuals for hardship or other reasons, do we really have a fair cross-section of our community? And I would say that courts have to challenge themselves all the time to ask that question and to make changes to ensure that we do have a fair cross-section of our community. So in Arizona, we're evaluating the source lists we look at to receive jurors, MVD, the voter registration rolls. Should we be using other source lists to try and summon additional individuals to ensure that we're getting a fair cross-section with reliable addresses? Are we overcoming those obstacles of hardship that are preventing people from coming to court? Somebody that may not be able to miss even one day of work are we able to ensure that that person can come and serve on a jury, just like somebody who is retired enjoying their multi-million-dollar retirement account? So I think we as courts have to continue to challenge ourselves all the time to ensure that we do have a fair cross-section of our community.
I also think there's a component to the jury that the jury reflects the community, and the community sometimes needs to change. So when I started as a prosecutor in 78, we established a special assault unit to do sexual assault cases against children, and more along the lines of the non-consensual sexual assaults. And, I was a really good prosecutor. I had 3 not guilties in a row because the jury wasn't ready to think that the nice coach of that basketball team could molest one of his players. They didn't want to think that that Boy Scout leader could take one of the little Cub Scouts and have molestation with him. And it took a while for the community to reflect what was, okay, we're seeing that this has got to change. So, it's one of those things that is the judge or the jury better at this or that. That's not really the issue. The issue is, the jury will reflect a society, good and bad, but you will also see change. And, I've actually got to the point now where, people say kids never lie. And I was like, whoa, let's not go that far. But, they, as opposed to where it was, 45, 50 years ago, that's a big change.
The jury can also be provide an incredible amount of information. A jury trial. I mean, if you think about the Me Too movement, in prior years, a lot of the kinds of cases that you were talking about with sexual assault, sexual harassment were swept under the rug. There were private agreements. They never saw the light of day. And so it led to people thinking, well, there's no problem there. We're not seeing the problem. And I do think having jury trials where these kinds of actions are writ large, are made available to the public. I mean, this is one of the reasons why a public trial, it can be really so valuable. It can educate people about what is going on. And then the jury is there to make a decision on the basis of its intense interrogation of the facts.
I guess I would also add that it's not just the judge's admissibility rulings where the judge makes a difference. It's throughout the entire jury process. And so there should be a very strong judge-jury relationship, and the jury looks to the judge for explanations, for a framework in terms of instructions, for understanding some of the processes. And so I know this is about the mystery of the jury, this panel, but the judge helps to demystify the process for the jurors. And I think that's a really integral role. I mean, I think this connection between judge and jury is so important. And one of the ways that the judge can protect jurors, and this came up in one of the chat questions, is by making sure that they don't feel threatened, that they don't feel that their picture is being shared, that they feel protected so that they can do the work that they've been asked to do. And I think most judges try to protect jurors and try to make sure, sort of create a bubble so that they can do their task. And afterwards, if jurors want to talk to the press, they can, but they don't have to. And so part of what a judge does is to tell jurors what they can do and they can't do, but also if they can't do something, to explain why, what is the reason, the because. And then, jurors for the most part do follow what the judge says.
Yeah, one of the questions was about social media use, sometimes by jurors. And I know that's been a problem that has plagued the courts when it's discovered that a juror sitting on a trial has posted to social media. And one of the kind of interesting things is, a lot of people think, oh, this is just so horrible. How could anybody even think of doing that? Well, many people actually use social media for help. It's the way they get through the day. They, pose questions to their friends on social media. And so when they're in this very different, sometimes very isolated experience, it's kind of understandable that they might reach out to their friends. And so again, the challenge for the judge is to explain why it is that social media use is really inappropriate and cannot be done by a sitting juror. And I think judges who do that actually are quite successful at limiting and possibly even eradicating the use of social media by sitting jurors during the trial. Again, the idea is, not only just a prohibition, but an explanation for the prohibition. That's the most powerful way to convey to the jury why it is that you're asking them to do this to promote a fair and impartial trial. One other thing, I'm guessing the judges might feel this. Jurors tend to love their judges and really look up to them and look up to them for guidance. And that does actually put something of a kind of constraint on judges. They have to be mindful about ways in which they conduct themselves so as to ensure that fairness and impartiality for the two sides.
Right. Professor Hans is absolutely right. The jurors are looking for someone in the courtroom who they can trust. And the lawyers and the parties have a stake in the outcome. But the judge is somebody who's fair. And, I always use humor in the court. I know not every judge likes to, but jurors always tell me afterwards, when you told that joke at the beginning of voir dire, it really relaxed me. And I realized, this isn't going to be as tense and formal a situation. And I was able to get into my role as a juror rather than being afraid that I'm going to do something awful and the judge is going to admonish me or kick me out or something like that. But it is an important role to play as the judge because, sometimes judges convey to the jury through facial expressions or otherwise what they think of a witness or a particular case. So you have to be very, very careful to keep that judicial poker face in there because you have a lot of influence on the jurors.
One of the things that judges can do that it touches on the bonding aspect that Professor Marder raised and also what Judge Lasnik just said is to explain the evidentiary rulings. And instead of just simply saying sustained or overruled when there's an objection, is to say that raises the question of X, and that's governed by Rule Y. And Rule Y says that the evidence can be admitted if these things are satisfied, and here they are or they're not. And what that does, I think, with the jurors is it begins to teach them how to think about the instructions that they ultimately receive as to the law, how to think through evaluating what has happened in the courtroom and what the evidence has suggested in finding facts. I would agree that judges have a tremendous effect on jurors and their approach. And I would speak for probably both the judges on this panel as well. It's a pleasure when you can go back and talk to the jurors after the case has been resolved and the verdict has been given and see that these jurors enjoyed the process. They had more confidence in the process, having been there, and they're the best advocates for serving on a jury going forward.
Great. And, I did a case with the Hells Angels up here. It was a really tough case. And the prosecutor, in rebuttal closing argument, I picked an anonymous jury, the only time I ever did, because the Hells Angels have a history of tampering with jurors. But in the last 90 seconds of the prosecutor's closing argument, he committed what I told the jury, that's the trifecta of prosecutorial misconduct. He vouched for one of the witnesses. He told the jury they were the conscience of the community. And he told them that their verdict would send a message to outlaw gangs. And I said to the jury, those are three absolutely inappropriate arguments. You are not the conscience of the community. You're here to determine the facts based on the evidence. You're not sending a message to anyone else out there. You're deciding whether the government has proven it, and so on and so forth. And, the appellate court said, because Judge Lasnik took the time to explain, not just sustain it wasn't even an objection. I didn't wait for one. I just said, this is so wrong. And why, that they said it wasn't prejudicial misconduct. So it's better for you, it's better for the jury, and it's the right thing to do.
And if I could pop in one question in the chat to the judges in the group, how often do you suspect a decision is made on the basis of emotion rather than on evidence? And if that's your suspicion, what do you do?
I was actually just typing a response to that.
Okay.
So I will delete my response, and I will just share what I was typing. Personally, I have not experienced any case in which I believe that the jury returned a verdict based on emotion. However, in observing the jurors during trial, it is not uncommon to observe the jurors reacting emotionally. And I think it is the judicial officer's responsibility to ensure that we give those individuals time and space to be able to take a break, to be able to recover from that experience, to be able to assess whether they continue to be fair and impartial or whether they're unable to decide the facts based only on the evidence and testimony, or whether they believe that emotion is now going to overwhelm them. And jurors do come to us and tell us that they're not able to proceed as jurors as a result of a triggering event, as a triggering testimony, or they just are becoming too overwhelmed with emotion. In Arizona, in our county, we also connect our jurors, or we give them access to counseling services after jury service. On occasion, some of our jurors need that help because these are experiences, testimony, and topics that are oftentimes outside their daily lives. And it is extraordinary what we ask them to do. And sometimes they need that help being able to process that. So my answer is I haven't had that experience, but I think we have to be responsive to those reactions to the testimony and evidence and make sure that we give the jurors time and space to assess whether they can proceed.
And I would say, I'm not saying it never happens, but sometimes judges make decisions based on emotion too. So it's just part of being human. I don't think it happens more with jurors than it does with judges, because there's 12 people or more who can sort of calm down the one, as opposed to the judge, who is usually by a trial judge by herself or himself. But what we have to prepare the jury for in really emotional sexual assault cases, child abuse cases, is that they're going to hear some very emotional and damaging testimony about something here. And if anything is going to trigger something that happened in your life, you need to know that. And if you want to talk about it outside the presence of the other jurors, we can make accommodations for that. But it's tough in there. There's a lot of emotion, a lot of trauma sometimes, and people can get blindsided if you haven't prepared them.
I think that the juries, though, in my experience, work really hard to follow the instructions and to make decisions based solely on the evidence. A couple of indicators that has happened is when you have a mixed verdict. So there is a criminal case and there are multiple charges, and the defendant is acquitted on some charges and convicted on other charges. Another indication is that the jury distinguishes between those counts or charges or claims that they can render a unanimous verdict on and those that they can't. And I think those indicate a real sophistication on the part of the jury in understanding what their obligation is. I once had a case that had more than 50 different counts in a criminal case. And the jury was out for a long time in deliberation. And of course, the popular belief is that if it's a long time for deliberation, it's going to be a defense verdict. Well, the verdict came back and the defendant was acquitted on some counts and convicted on other counts. And in cleaning up the jury room, my staff and I ran across a board on which numerous pieces of paper had been placed, and on each one of those pieces of paper, a count was listed, and the evidence was listed, and the elements that had to be proven were listed, and the jury had applied those elements and the evidence to establish whether or not they thought it had been proven. And that's what led to the determination of acquittal on some counts and conviction on other counts. A very impressive job by the jury.
And there have been earlier studies showing that there's a lot of judge-jury agreement on verdicts. One very famous one is Calvin and Zeisel back in the 1960s, that judges and juries agreed on verdicts, about 3/4 of the time. An anecdotal example I can give you is the district court judge that I clerked for. He had been on the bench 15 years. And he knew that I had an interest in the jury and he had an interest in the jury. And he told me he could count on one hand the number of times he had disagreed with a jury verdict in 15 years. And for those few times, he understood why the jury did what it did. So there's a lot more agreement than might be widely understood.
One of the things is that we do count on, and I think it is sometimes effective, on the process of deliberation to handle some of the emotional reactions that particular jurors may have to the testimony. And that gets me to one of the, I think, gaps in our instructions to jurors, and that is how to go about deliberation. That if you look at typical jury instructions, they usually don't include detailed information about what they should do once they get into the jury room. It's usually, hey, jury, here's the case, go into the jury room, come back with a verdict, won't you? So I guess one thing, I mean, there's a good reason for that, and that is to preserve the independence of the jury during this very critical phase, the decision-making phase of the trial. But probably one type of instruction that could help is to encourage the jurors, saying it's their determination how they structure their deliberation. But one thing they might want to consider is having a general discussion of the evidence rather than doing what I think lots of juries are tempted to do, is take an initial vote right away. One of the things we have learned from research is that those taking an early vote right away to see where you are actually increases slightly, but increases the likelihood of a hung jury. Maybe because once you have actually expressed even a tentative verdict preference to other jurors, you're kind of committing yourself publicly to it, and it may be harder for you to change your mind if you hear compelling other interpretations of the evidence in the case. So I think that's one thing I would like to see added to typical jury instructions.
If you wanted a popular example of that, all you have to do is look at that great jury film, 12 Angry Men, where they walk into the room and they take an immediate vote, what we call a verdict-driven deliberation, and then they get, really entrenched in their positions. So the better way is, as Professor Hans said, to just wait and to have a group recollection before you start taking votes. So
I put in a plug. Our next Law and Literature session, Julie Emprick, who's the facilitator, is part of the audience, will be on 12 Angry Men. So join us then for that. And I'm going to pop 2 questions in and then disappear. Is it ever appropriate to abandon the rule of law for jurors? I'm curious to see what the answer will be there. And if any of the judges experienced juror nullification. And I just have to compliment these hot groups of questions that we've had. Thank you.
I think jury nullification is a very difficult and one we probably disagree on. I would not favor advising the jury that they have the power of jury nullification. I think it's better to tell them the burden of proof is this, and if the party meets the burden of proof, your verdict should be for that. Because, in my experience, jury nullification was charging that white man with killing that civil rights worker down in Mississippi, and the jury nullifies the murder charge by saying we're not going to convict a white man for killing a black guy or a Jew from New York who came down here to cause trouble. So I have a real strong reaction to, if the jury wants to nullify, they got the ability to just vote not guilty, but I don't want to send them it's okay with me to do it. Now, in the Northwest, after Judge Bolch made a ruling that gave the Indians, based on treaties from the 19th century, the right to 50% of the catch in certain waters in Puget Sound, and white fishermen just totally ignored it, kept fishing, got charged. Juries found them not guilty because they totally disagreed with that ruling. And, look, I was product of the 60s. If I were on a jury with Abby Hoffman and those guys, I'd probably nullify the charges against them. So, but I wouldn't want it to come from the judge that it's okay to do it.
I think that jury nullification as a concept is more theoretical than it's easy to establish that it occurs. And the reason is because, just as Judge Lasnik mentioned, juries are presumed to follow the instructions that they're given. And one of the things that they can do is to assess credibility of witnesses who testify in the courtroom. So rather than presuming that a jury is nullifying or not following the law, it's more likely that if there's anything in the record that supports the position that the jury has taken, that it is just accepted as part of the jury's role in determining the facts.
So I agree with both of my judicial colleagues on this panel. The other thing I would say, in Arizona, after the elimination of peremptory challenges for our courts, we shifted to the use in many cases of a digital questionnaire. And so our jurors receive case-specific questionnaires, and they have the ability to provide the parties and the judge comments on their opinions, their life experiences, their attitudes regarding the issues in the case. So for example, if an individual has strong feelings regarding the law and the legalization of certain substances, and if we're in a case involving a possession of dangerous drugs, but an individual has very strong views on the legalization of that particular drug, that's an important piece of information for the judge to hear, for the parties to hear, and for the analysis to be made whether that person is a fair and impartial juror in this case. Perhaps they are, perhaps they're not. But I think it's important, so we try very hard to ask our prospective jurors about their opinions, their attitudes, and their life experiences to gather that information for us to be able to assess whether they are appropriate jurors in certain types of cases.
There's a little bit of research on jury nullification, and like Judge Lasnik was saying, the history of jury nullification shows some instances where jurors really are fantastic, and the community, especially contemporary community, is thrilled and overjoyed that a jury nullified what was a bad law at the time. And then there are other times when it's shocking and terrible, and you wish juries would not nullify. I think today the kinds of examples, like the fishing example that Judge Lasnik gave, that's rare. That's few and far between. And really that kind of dramatic, all the evidence points toward guilty and the jury votes not guilty would be extremely unusual, extremely rare. What is probably more common is people's life experiences and perspectives feeding into assessments of credibility, like Judge Krieger was talking about, or assessments of some of the facts, and probably occurs more in cases that are right on the edge of ambiguity, like a verdict could go either way, not one where the evidence points really, really strongly to one side or the other side. Those are the kinds of cases where people's attitudes and perspectives might affect their interpretation of evidence. So that's where I see, I guess you might call it soft nullification, as opposed to the more extreme versions that we've been hearing about.
And I guess I would add that nullification does not happen very often. And if it did, maybe that would be more of a problem, but it doesn't. And my answer is diverse juries. So to some of Judge Lasnik's examples, if you have an all-white jury, then I'm deeply suspicious, much more suspicious. But if you have a diverse jury, then you're less likely to have that happen. But when it does happen, I do think it signals something about perhaps the lack of support for a particular law, say 3 strikes law in California, for example. But I guess if you're willing to heed the message of nullification, you have to accept that it could happen in cases that you agree with and cases that you disagree with. I agree with Judge Krieger. If you think about O.J. Simpson and the portrayal in the press was that was one of nullification, but I argued at the time that it really wasn't. It was assessing of witnesses and experiences with the police, and that could shape how you see the evidence that was presented in the courtroom. So again, if it started to happen a lot, then we would have a problem. So far, so good.
Let's see if there are other questions here. Denise, are there some that we haven't answered that?
No, I think that this group covered everything in the best possible way. And one of the things I was lucky enough to hear this wonderful panel rehearse this topic, it gives me, like, in the best possible way, Judge Krieger, civics education feeling, the idea that the government matters, that there are important people on every side, that there are smart academics who care deeply about the topic. I just want to thank you personally and on behalf of Berkeley Judicial Institute. Want to thank you for proposing that we take this topic on, and then for this panel for offering this program, exceeding our high expectations. While I'm thanking people, I have to thank all the participants for great questions. Grateful that this program has been recorded. As Justin said, it will be on our website by the end of the month. Think just sort of as all smart people do with the good information they have, think about coverage of trials and where you see things and how it could be better. If you're brave and you're a judge, think about doing what Judge Lasnik does, what Judge Krieger does, what Judge Gates does, sometimes talking to media, never about the cases before them, but things on background, all good. But Judge Krieger, this has been your labor of love. Any closing remarks for the group?
A big thank you to everybody. I think this has been a learning experience for me, and I hope for the people on the panel as well as people in the audience. Thank you for participating in every way that you have, and thank you, BJI, for hosting us.
Listen to us. What a way to start a weekend. All right. Thanks to everyone. Take care. Thank you.